Welcome to Family.Inc. Expert Interviews. Today I have the pleasure of speaking with Megan Jerabek. Megan is a shareholder at Briesen Roper in Madison, Wisconsin. Today's discussion is titled Estate Planning Essentials, the Top 10 Must-Have Documents. Before we begin, a little housekeeping. If you have any questions throughout the session, please use the Q&A button at the bottom of your screen. Megan, welcome.
Thanks. Happy to be here.
Thanks for coming. Before we begin, I want to read a little bit about you, as I think it helps frame the conversation. Megan is a shareholder, co-chair of the Trust and Estates practice, chair of the sports law practice, and a member of the business tax and real estate practice at Briesen Roper in Wisconsin. You serve as a personal general counsel for individuals, families, family business owners, professional athletes, entertainers, and entrepreneurs. Additionally, your practice focuses on trust and estate planning and administration, business formation and succession planning, real estate sales, acquisition, and business transactions.
You got it.
Okay.
Good mouthful there.
Yeah, that's exactly right. I'm not done. Frequent presenter on a variety of topics in trust, estate planning, business succession planning, charitable giving, real estate, and a frequent presenter on name, image, and likeness, NIL, for college athletes and businesses, highlighting the opportunities now available for both while staying compliant with NCAA regulations and state laws governing the topic. And I know that it's incredibly germane, especially right now, given last week's ruling. And if we have time at the end, I would love to talk about that as well, because I think it's really fascinating. I think people are interested. Graduated University of Wisconsin-Madison, JD from Marquette.
You got it.
I love it. Estate planning documents, top 10. Where do you start with estate planning? How should families be looking at estate planning? What's the first step?
Yeah, good question. So the impetus for a lot of people to start on estate planning is often either they've had a family member pass away, or an aging family member who they're trying to help them get their affairs in order, or they are working on succession planning for their company, or their wealth advisors or accountants or other people are telling them it's time to get an estate plan in place. And so oftentimes those are the drivers for people to start thinking about this. But the first step for people usually is to reach out to an attorney who works in this space, because despite it being something everybody needs and everybody is going to have some interaction with at some point, this topic is something that very few people know a lot about, that don't work in this industry. And so you can be a really successful family business owner, doctor, accountant, even lawyer in other practice areas and know little to nothing about this. Yeah. And so it's important for people to know that that's okay. And so oftentimes giving us a call is the first step to starting down the path of planning, because the first step really becomes then education on what does planning look like? What kind of a plan do I need? How do I know what documents I should put in place and whether I have a complete plan or not?
Before we go into the types of documents and how to look at this, I want to kind of lean into the emotional side. People struggle with going through this process, and I'm curious, what is it about estate planning and this process that makes it so challenging, and why people don't want to own the process and the outcome and so forth? What do you see?
Yeah, I think there's a couple of things. I think one I touched on a little bit, which is the feeling of, I am an educated, smart, successful person. I should understand this topic. I should know more about it. I shouldn't have to ask such basic questions or admit that I just don't know. Start at the base. Yeah. And I think that's a common misconception amongst people that can be a stumbling block, especially for successful people who are used to knowing a lot of things and feeling like they can handle a lot of different topics without a whole lot of education. Yeah. This just doesn't happen to be one of them. Another stumbling block often is people think, well, I need to know what I want before I contact a professional, because they can't help me unless I know what I want. And I just haven't really, I can't figure out how to focus it in my brain. I can't reach a conclusion and then call somebody up and tell them what that is. And I think that is a a stumbling block for many. And it's actually really what a good estate planning attorney can help you with, is to lay out the options for you in a way that makes sense, that help bring things into focus a little bit for you, and also help get you unstuck. The third stumbling block is you're stuck on something. You're stuck on, well, who's going to take over the company? You're stuck on who's going to be guardian of my kids. You're stuck on, I don't exactly know how to structure the inheritance for my family or what tax planning to do. And so you're just kind of frozen.
Yeah.
And hopefully reaching out and being with an estate planning attorney that communicates in a way that helps you get unstuck will kind of overcome that barrier. It's hard to do on your own.
So takeaways for those who are ultimately going to watch this on Family.Inc platform. Get vulnerable, be okay asking questions. You don't have to know the answers, and lean into the process even if you don't have the answers. Rely on your attorney to help guide you through that and to lay out options. Just putting it out there so everyone hears it right in the beginning. Because
And the reverse to that, or the complement to that, is you want to find an estate planning attorney that you feel comfortable doing all those things with. Because you do have to feel comfortable asking questions. You do have to feel like you're getting answers that make sense to you. You do have to share really personal family information. So you want to be with somebody that you feel like you can do that with. And there's lots of good estate planning attorneys out there. So you should feel empowered to find one that you like match with personality wise to make that easier.
yes,
It's gonna help the process in the end.
Yep. No, that's great. Okay, so let's talk about documents, plans, and the way to look at the strategies behind estate planning and what you need. Two different tracks. Can you walk us through what that looks like?
Yeah, so really the basic part of estate planning is to understand that there's two different types of estate plans. An estate plan that uses a will as the main document, and an estate plan that uses one or two revocable or living trusts. They're the same thing, different lawyers just use different names.
Okay.
And the difference between the two of those, people often think a will is the main estate planning document, and traditionally that was the case. A will utilizes the court process to transfer assets at death. So if you have a will and you pass away, your will gets filed in the courthouse in the county that you live in, and a court process begins called the probate process.
Okay.
And that's generally speaking the court-run process of collecting someone's assets, paying their final bills and expenses, distributing out what's left according to the instructions in the will.
Okay.
So that's what most people think of when they think of an estate plan.
And Megan, that is the probate process.
That's right.
Sort of like adding it all up, paying the taxes, and then distributing.
Exactly. And what makes it the probate process is that it's court run on that piece. So some people think if I have a will, there won't be a process because I said what I wanted. But actually, the court is the only place that a will can be administered.
And that is a public process too, correct?
Right. Yeah, it's public record. It has a second layer of administration. So not only are you doing the work, but you're reporting it to the court. So there's kind of this extra piece. There's hearing requirements in some cases. There's notice requirements and other things. So it is a formal process that is run by the court.
Okay.
And so the majority of people, especially business owners, do not want to be part of that process, mostly because of the public record nature of it. And they want the confidentiality of a non-court administration.
Mm-hmm.
And so to do that, you switch from a will plan to using one or multiple revocable or living trusts. And there are lots of different kinds of trusts out in the world. And so if you've seen one trust, you might think, well, this is what a trust does. This kind of a trust is the most commonly used trust there is. It's the most flexible kind of trust. And the purpose of it is court avoidance at death. That's the point of this kind of a trust. And you can think of it really as like the creation of a bucket or a pot. I tend to use my hands when I talk, as you can tell. I usually use flowcharts to help you understand.
I will do the same thing.
Okay, deal. We're even.
Yeah.
And so if you think of a trust as like a bucket or a pot, you're creating this bucket while you're alive called your trust. And the goal is then to fill up the bucket, to put your assets into the trust while you're alive, or to name the trust as a beneficiary on assets at death, because whatever is in the bucket when you die or transfers to the bucket by designation, transfers by the trust agreement outside of court. That's how this kind of a trust works. And
Okay.
it's private, it's confidential, there's no court interaction, there's no filing then of kind of what you had when you passed away and things in a public setting.
Yeah.
And so for family business owners especially, it's by far and away the more common approach.
So two thoughts come to mind. Why wouldn't everybody use a revocable trust?
Mhm.
And if there is a reason why, is there a threshold that you would say is if above X in terms of assets at death, you're gonna use a revocable trust? But like, why wouldn't everybody?
Yeah, most people do is the answer.
Okay.
So in our practice, probably 99% of my clients are
Okay.
in a trust plan. The people who use will plans either maybe did it themselves, found it online, did it quick before they went to Mexico on vacation on spring break when their kids were little and never updated it, as a random
This
example.
this sounds like like an example you've seen.
Yeah, exactly. My March gets really, really busy with emergency estate plans
My
before spring break.
goodness. I love it.
Yeah, and so usually it's somebody that maybe just did it themselves, or they did it when they were really young and new to this process and just haven't updated it, or maybe they worked with a lawyer that told them, listen, the court process isn't that big a deal.
Okay.
Now, the court process isn't a big deal for lawyers. I don't mind going to probate. It's fine for me. Do
Sure.
you want to do it? No.
Right.
So not a lot of people, especially family business owners, I really can't think of a good reason to use a will plan for a family business owner at all, or anyone who wants confidentiality.
Right. So recognizing the percentages, let's talk about that will plan and what is included or needs to be included in that plan and the different documents and the things that people need to be considering as they develop that.
Yeah, so if you have a will plan or a trust plan, okay, that's one document of an overall foundational plan. Okay, so I'm going to use the trust plan as an example since that's what most of the people watching this would need. If you have a trust plan, the trust is like the meat of the plan then, okay? It's got everything in it that says who gets what, when, and how. That's all in the trust. But the trust is surrounded by other documents that serve other functions to make up a full foundational plan. And so an example would be if you have a trust plan, you are also going to have a will. Your
Okay.
will then becomes a backup to the trust. And it says, if something gets caught up in court after I die because I did not get it to the bucket, okay? The will says then dump that asset back in the trust and get out of here. It's called a pour over will. And the hope is that it's never used because we don't go to court with anything. Okay.
And
But it
Megan,
should
real
be there.
quick, would it be if I had a piece of property and for some reason I didn't title it correctly, all of a sudden it ends up in my estate, I die, the will would catch that and move it back into the
Yep.
trust. Okay.
Yeah, great example. Yeah. And there are ways, depending on what state you're in, there are ways we tend to have backups between the trust and the will. So for example, in Wisconsin, we can do something called a marital property agreement that says if I die and I left something in my own name, like your example, the piece of property, use this marital property agreement to pull it into the trust outside of court.
Got it.
Okay. That's post-death funding. Some states allow that.
Okay.
So that would be an example of something that's between the trust and the will, okay?
Yep.
So we have backups to the trust because our goal is court avoidance, but you're exactly right. If none of those backups work and we're stuck with something payable to your estate, the pour over will is the way we get it back to the trust where we wanted it in the first place, okay? And then the third kind of financial piece to your plan then is a financial power of attorney.
Okay.
A financial power of attorney is a lifetime document that allows you to designate somebody to help you with your financial matters while you're alive if you need help. Okay? The way that works with the trust is that the trust is run by a trustee.
Yep.
The trustee's job is to run the bucket. They only have authority over what's in the trust on the day they're acting. Okay?
Okay.
While you are alive, there are other functions that do not have to do with the trust that someone would need to help you with if you couldn't do them. Examples would be filing your tax return, dealing with your retirement accounts, filing for Social Security, submitting paperwork to your employer. Those are all financial functions, but not the job of the trustee because they don't have to do with dealing with the bucket.
Got it.
Your financial power of attorney takes care of all non-trust financial matters if you need help. Make
And
sense?
can your trustee be your financial power of attorney as well?
Most people have the exact same person in all three of those documents.
Yeah.
Their financial agent under their power of attorney, their successor trustee under their trust, and their personal representative, or some states call it executor of their will.
Yep.
So theoretically, you have one financial decision maker. They might just be wearing a different hat on a different day, depending on what they're trying to do for you.
Okay. I want to just jump in, excuse me, to the revocable trust. Trustee and beneficiary and how that works. And can you be both? How do you structure that and how do you look at that?
Yeah, great question. So there are three roles of a trust. The creator of the trust, that's called a grantor or a settlor, okay? Yep. The trustee of the trust who runs the bucket, and the beneficiary of the trust who the bucket is for, okay? In a revocable trust, you are all three while you're alive. Mm-hmm. So the best way to think about it is a revocable trust is by you, for you. Yep. While you're alive, you can do anything you want with the trust bucket. You could put things in it, take things out of it, gift it, buy it, burn it, sell it, mortgage it, whatever you want to do. This kind of a trust does not change your ability to access the assets, to control the assets, to use them, does not change taxation or reporting or anything like that in this kind of a trust. Okay, because you're in all three places. Mm-hmm. After you pass away, then somebody else becomes trustee, and the beneficiaries are the people that you wrote into the document should receive your assets when you pass away. Your spouse, your kids, your neighbors, your friends, charities, those are the beneficiaries after death. Okay.
And we're using the trust to keep it out of the courts and to keep this private. Let's talk about taxes related to having the revocable trust and how those are handled at your death.
Yeah, great question. So a trust, this kind of a trust is not a separate taxpayer while you're alive. There is no fee for doing it. It doesn't go on file with anyone. It does not have a separate tax ID number. So while you're alive, you are the trust is you, okay, from a tax standpoint. Yep. After you pass away, what you can do in a trust versus a will is really the same. You can do the same tax planning in either document. And that tax planning has to do with what kind of buckets are we going to create after death to soak up any sort of tax exemptions that are applicable. And if we have time today, I can certainly talk through how taxes work in this country on death. That's an education piece that most people need from the start. But from a tax planning standpoint, a revocable trust has no tax impact while alive. Yep. And post-death, you can definitely do tax planning post-death in your trust or your will.
Okay. Let's table that for a minute. Let's talk about other documents that somebody needs to have in place.
Yeah, great.
Before I go on summer break to the beach.
Yes, exactly. Before you get on spring break, this is what you need. So those were the three financial pieces of the plan, or four if you're in a state that allows that post-death funding. Okay. Yep. Then the next piece of the plan is your healthcare portion of your plan. And the number of documents that make up the healthcare portion depend on what state you're in. But generally speaking, they include three documents, sometimes all as one, sometimes as three separate. The first is a healthcare power of attorney. That nominates someone to make your medical choices for you when you can no longer understand or communicate your wishes. Okay. Yep. Sometimes that's called the healthcare surrogate designation, a healthcare power of attorney. Different states call it different things, but the function is the same.
Single individual, multiple individuals, how does that work?
In most states, your healthcare power has to be one at a time.
Okay.
They don't want you they don't want the doctor waiting for a deadlock to resolve while you're needing surgery. So most of the time it's one person at a time.
Okay.
Then the next document that might be included in the healthcare document, or it might be separate depending on your state, is called a living will or a declaration to physicians. Living will is a term that people use on the street to mean a lot of different things. People refer for example, to the will I talked about earlier as a living will. It's not. That's your last will and testament is what that's called. Okay.
Okay.
A living will is actually a healthcare document that is a document in which you will decide for yourself whether you do or do not want feeding tubes and life-sustaining measures if you're in a vegetative state or terminal condition.
Yeah.
It's the pull the plug document, for lack of a better term. That's what living will actually is.
I
Okay.
can't imagine why people struggle to make these decisions and actually go through this process, right?
Yeah,
These
the
are hard
living
things to
will is
discuss.
interesting because it's just to check the box of all the decisions you have to make. That one is like pretty easy to effectuate. You just check a box.
Yeah.
But it's very end of life. Sometimes people think that's a DNR. It is not. A DNR has to be done with your doctor. That's not done with lawyers. This is a very, very limited scope document. It just deals with vegetative state or terminal condition and whether you want those, feeding tubes. So it's pretty limited.
Okay.
And then the third document that we implement is called a HIPAA authorization. That is for privacy purposes for healthcare, and it designates who can speak with your physicians to decide if it's time to step in and help you.
Got it.
We have a separate document that does that. Sometimes they have that right in the healthcare power or in the living will or both. Your doctor's offices will also have HIPAA privacy statements that are different than what we're talking about.
Okay.
So
Right.
those are the three pieces that make up the healthcare portion of your plan.
Mhm.
And like I said, they might be a little different depending on the state, but the function is really the same across the board.
Okay. Other documents. We've got financial, we've got healthcare.
Yeah. So the last batch of documents then is a funeral or burial document. It used to be that people would put their funeral and burial decisions right in their will. But wills don't get read for multiple weeks often after someone passes away. So you can imagine kind of what was happening,
That's a
right?
problem.
Like, ooh, shoot. She actually wanted to be cremated and we just buried her next to grandpa. Like, what do we do now? Right? And so states created separate forms that allow you to nominate someone to make your funeral and burial choices, much like a healthcare power of attorney, and also allow you often to write what your wishes are. Okay. And it doesn't deal with anything else. Doesn't say who gets the money, doesn't say who's appointed in other roles. It's just limited to the health or to the funeral and burial.
Okay.
And so if you know that you want to be cremated and no viewing and big party, you can write cremation, no viewing, big party. And now your friends and family know it's separate from anything related to the finances. So it can be pulled out and looked at right away after someone passes away. Without kind of revealing any of the rest of the plan or having to get into the money or anything like that.
Yeah.
It's called something different in every state. And some states don't have their own form, but you can do it as part of other documents. So
Okay.
that's like the third decision-making role. So we have financial, we have healthcare, and we have this funeral and burial representative.
Okay.
Okay.
Other documents or other provisions that are often in place that you guys are building into these or separate documents, property, what else
Yeah.
is there?
Yeah, so if you have a trust, you are also going to have funding documents, okay? You have to fill up the bucket. How do you actually move your assets into the trust, okay? The attorney should provide you with funding instructions at a minimum that will tell you, here's what to do with your bank accounts, your investment accounts, your real estate, your stocks and bonds, etc.
Yep.
Usually it's broken down by asset type and it tells you how to get it in the trust.
Got it.
So that is one piece that's important to have if you have a trust plan.
Mm-hmm.
One of the major things that people need to know is a fundamental part of your estate plan is beneficiary designations. Okay.
Yep.
And this gets a little bit to that do-it-yourself estate planning that sometimes we see is where people start to put designations on everything instead of having a plan. Okay. They'll just list beneficiaries on all different things. One thing that's important to know is beneficiary designation forms trump everything else. Meaning if you have someone listed as a beneficiary on your life insurance, and that policy was from ages ago before you had 3 kids, you only had 1 kid and that's the kid listed, that kid's getting it. That company is going to pay to whoever their form says to pay to. No matter how much kicking and screaming we do, about what you really wanted. So
Absolutely.
making sure that you have updated beneficiary designations, especially on life insurance and retirement accounts, is extremely important no matter what kind of plan you have.
So Megan, if I didn't have a revocable trust in place, I designated my firstborn son. I have a daughter later. I create the trust later on. I don't update that document. Henry, in my case, gets the proceeds of that life insurance policy, not the trust, not Juliet.
Yeah.
Okay.
Yep. And that is not what you want, right? And
Nope.
so when you have a trust plan, oftentimes what we'll have you do is list potentially your spouse first and then the trust second,
Yeah.
or maybe the trust right away
Mhm.
versus going to individuals, because the trust will contain all kinds of contingency planning. If you have more kids, if a kid passes away, if you have grandkids, all of that's in the trust document. So
Yep.
oftentimes when you create a trust, you will be asked to update your beneficiaries to remove people and
Yeah.
list the trust instead.
Yeah.
And that's a better receptacle for most often. That's advice that you'll get with your planner on the kind of plan you have, but that's usually what it's going to be.
You know, it's interesting. If I think about families, growing families, and somebody that has substantial assets or not substantial assets, assets, period. The last thing you're thinking about when you have a kid is updating your documents because you're just trying to survive, uh, you know, a newborn, right?
Newborn. Yeah.
And I would imagine you run into this situation where something happens and people do forget. It's very easy to forget to update these documents when you're just sort of living life and like there's a lot of stuff going on.
Yeah. Yeah. That's right. It is easy to forget. Wealth advisors actually are really good at reminding you, which is great. So you should rely on your professionals, hopefully to give you those triggers. Usually we as lawyers don't always know when people are pregnant or when they're, having a baby or adopting or however they become a family.
Right.
But a lot of times wealth advisors do, or accountants. And so those are good professionals to help remind you, but you're exactly right. There's a lot on your plate at that point. Getting a trust plan like this in place and updating it to the trust means you don't have to think about it
That's
moving
done.
forward.
Yeah.
And that contingency planning is already in there.
Yeah.
What we often see actually is that people listed their spouse and then stopped. And then what happens is if your spouse survives you, great, they get the asset. But if your spouse predeceases you or you pass away together, now we have an asset without a designation. That's an example of an asset that would get paid to your estate, most likely, and
Yeah.
we would need to pull it back into the trust through that court process.
Got
So
it.
that's actually more what we see is
Okay.
that people have accounts that don't have backup designations.
Mhm.
And so it's very possible that they could end up without a named beneficiary.
Okay.
Yeah.
Let's talk about if I think about financial advisors or advisors for families on a whole and how you integrate and work together, working with families. What does that often look like? How should families be thinking about bringing everybody to the table to talk about this and build kind of a comprehensive plan?
Yeah, good question. You definitely want a team approach to your estate planning, for sure, between your wealth advisor and your attorney.
Mhm.
Um, if for no other reason, because the wealth advisor can actually help you do your homework, right? They can actually do the paperwork to fill up that bucket, to move the
Yeah.
accounts that they manage for you. They can make sure your beneficiary designations are done correctly or get you the forms. And
Okay.
so if for no other reason, making sure your wealth advisor and your attorney are talking about your trust funding, that's a really good thing that helps coordinate the plan.
Yep.
If you have tax planning that needs to be incorporated into your estate plan, then having your accountant or your wealth advisor and attorney, all three together on a call, can be helpful. And so it really is a team approach, and you want to work with professionals that are comfortable with that. It's a big part of what we do here. Almost all of my clients, I am in direct contact with their wealth advisors at a minimum, and often also their accountants to
Yeah.
coordinate the planning.
Okay. since we're talking about financial advisors, I do want to just touch briefly on taxes. And as we're thinking about tax planning as a part of this process, can you speak to that? Give us sort of we could have an hours long conversation, obviously, on tax planning, but just high level things that people need to be considering or thinking about as they're building out their estate plans.
Yeah, I'll give you the high level summary,
Yes.
just as that education, and hopefully people will stick with me and not turn off the video once they hear taxes, but I
Hang in
promise
there,
I won't
everyone.
make it more. Hang in there. It'll be short. So the way taxes work in this area is that in this country, when you pass away, we value everything that you own as of your date of death, and that is called your estate. Okay. And every estate is subject to what's called the estate tax, or depending on political party you listen to, death tax is another term that is used.
Yes.
Okay. It's actually technically called the estate tax. So the estate tax applies to every estate, but currently very few estates end up owing a tax. And that's because there are two types of transfers that are estate tax free. Okay. The first is you can transfer any amount you wish at death to your spouse or to charities free of estate tax.
Mm-hmm.
So that's number one. If you go to one of these, free places, you don't pay estate tax on what you give to them.
Yep.
So I could die with $110 billion and leave it all to my spouse, no estate tax on that transfer. Okay. If though you transfer it to anyone else, anyone other than a spouse or charity, then what you look at is how much are you transferring? Okay. The second type of transfer that is estate tax free is a transfer that is below the threshold set by the government. Okay. The threshold is called the estate tax exemption. That's a federal threshold. Some states also have their own threshold, but let's just ignore that for right now.
Yep.
The federal threshold, you can view it as a ceiling. Okay. If when you pass away, you give people less than the exemption, no estate tax.
Yep.
If you give more than the exemption, you pay estate tax on the overage.
Okay.
So that threshold is an important thing to understand in tax planning for this area.
Yep.
That threshold is set by the federal government and it moves each year. Okay. The ceiling is moving.
Yep.
And it's very, very political. Every time we get into a new political cycle with new elections, you will hear about the estate tax exemption because fundamentally, or maybe theoretically, the parties are very divided on it, on where it should be.
Yep.
And it's really easy to change. I should say as easy as legislation is to change, but it's moving a lot. Okay. The only threshold that matters is the one that applies in the year you use it. Okay. And you use that free threshold by either making big gifts while you're alive or transferring assets at death. Mm-hmm. Okay. So this year's exemption doesn't really matter to me unless I die in this year or make big gifts. Otherwise, that exemption is pretty irrelevant. Okay. Yep. And so the tax planning we do from a estate planning standpoint is looking at where are your assets compared to this threshold, okay, both today and where we think they're going. Yeah. And how do we plan for soaking up as much of that exemption as we possibly can, because that's free transfer, okay, free of estate tax. So that's the kind of tax planning we do here. Yep. If you are at or close to the threshold, or certainly if you're over the threshold, then tax planning becomes a fundamental part of your plan. Yeah. Okay. It's going to be it's going to be woven into your trust. Yep. And it might also mean you have other kinds of mechanisms that we're going to use, potentially other types of trusts or gifting plans or other things. Okay. That all is called advanced planning, and it's done for tax reasons, really.
Megan, how much?
I did it in like 5 minutes.
That was good. How much do we, this is a hot topic right now. How much do you need to soak up this year right now? And what does that look like going forward?
Yeah, good question. The current exemption is the highest it's been in history by millions of dollars. Yeah. Okay. Under the fiscal cliff legislation way back when Obama was president, it was set at 5 million under permanent legislation and indexed for inflation.
Yes.
Okay. And then when Trump became president, he doubled it through
Yep.
the Tax Cuts and Jobs Act.
Yep.
Okay. That the way he doubled it was done through a budget reconciliation process, not permanent legislation.
permanent.
And so it expires.
Yeah.
So we are currently still under the doubling. So this year's exemption is 13.6 million because of those inflation adjustments. Okay. Per estate.
State.
Yep. Per estate. Okay. But that high exemption will expire at the end of 2025, and the ceiling will fall back to where it would have been, but for the doubling. Okay. And so we don't know that exactly.
Inflation adjusted from the 5 from the Obama
From the
era.
5. Yeah. So it'll be about 7-ish, depending on where those inflation calculations come
But
in.
significantly less.
But it's a drop in about half, you know.
So over the next 18 months, individuals need to do some significant planning and understand where their estate is going to be potentially at some point in the future, and say, how do we move these assets out if we can from our estate?
Yeah, that's a real balancing act, right? Because the way we look at it is if the exemption is 13.6 now and it's going down to about 7, the difference there is what we call the bonus exemption.
Yeah.
That's the opportunity zone, if you will. Okay. That if you wait to do planning until the threshold is lower, you won't be able to use this bonus planning. Okay. You'll still be able to do tax planning. You'll still be able to do gifting up to a certain amount, but that bonus threshold will be gone. And so if your estate is over the exemptions, and if you want to take advantage of that bonus, that requires some pretty significant moves of money or assets, right? We're not talking about moving $1 million. That's below the threshold, even if it comes down. Yeah. We're talking about moving something north of 7. Okay.
Yeah.
And that's per person. So those are the people that we want to talk to and really make sure that they've thought through what their options are. Yep. And it's not just a balancing act of, well, let's just do the most tax efficient thing. You have to balance what comes with that, right? In order to do the tax planning, you might have to shift things into different irrevocable trusts. You might have to give them away. You might have to give up control over them. So it's a balancing act of tax planning and cash flow planning and lifestyle planning. All of those things go into consideration when we decide how are we going to take advantage of these exemptions and at what level.
Yes.
The other thing to keep in mind is the threshold is per person, but married couples can stack their exemptions. And what I mean by that is if I die and leave all of my assets to my spouse, I didn't use any of my exemption because my spouse was one of those free transfers we talked about. Okay.
Yep.
My spouse then can file an election at my death to absorb my unused exemption. Yep. That's what allows married couples to stack on top, because he would then have his exemption plus the one that he absorbed from me.
Yep.
Okay. Yep. So that really effectively doubles the exemption amount for married couples.
Yep.
And so that's important to know from a threshold standpoint.
Well, and this is what is so critical for families with private companies, and understanding the value of those companies, the shares, where that's going, how your business is doing, and doing some planning to make sure that you get in front of this, recognizing that unless something dramatic changes, that will sunset in January of 2026.
Yeah, the default is the sunset. So nobody has to do anything for it to go away. That's what's going to happen unless somebody acts and changes it. Yep. And so, and really, truthfully, if it sunsets, it's going to keep going like this. Okay. It's too political of an exemption to think that it's going to stay put somewhere. It's gonna keep moving. And so because of that, the tax planning piece is something that we reevaluate or look at, or we build flexibility into what we're doing, knowing that we're kind of working with a moving target. Both in your assets change over time, of course, and the exemptions also change.
Yeah.
So there's a lot of balancing that goes on with that kind of planning for all of those reasons.
Yep. Good.
Yeah.
Megan, any last thoughts? I do actually want to talk a little bit about NIL, but
Yeah.
any last thoughts on the estate planning process, or things that you want to just make sure all of the members capture and take away as a part of this discussion?
Yeah, I think you hit it on the head at the beginning. The major takeaway is, like, you do not have to have your plan crystallized in your head to start.
Yeah.
In fact, often our job as planners is to help you focus that plan in your mind a little bit through us telling you what we see a lot, the pros and cons of different things, how we could structure it, giving you ideas on what to do. You do not have to navigate all of that on your own. And in fact, the more complex your family or your assets or both, the harder that is to do independently. So understanding that it's a process, that there may be multiple conversations that have to be had before we even get to the type of plan we're going to use or how we're going to do it, that's okay.
Yep.
That's absolutely okay. And then I think understanding that the foundational planning is all revocable. You can change it at any time. This is not something that, like, oh, I just can't figure out how to get it right. It's like, well, let's get it right for today. And as things change, we can update, right? We try to help people look at maybe a 5 to 10 year horizon, because it's really hard to think about what we're going to want in 20 years, or where things are going to be, or how our assets are going to look. So just really understanding that, our job as planners is to help you work through that, and that there's flexibility in what we're planning so that you can take care of it today and it can grow with you as things change and develop over time. Those are the two things I would want people to know.
Get started, everyone. Just
Get started.
something.
Right. We're delightful people. You should just come in and chat with us.
Totally delightful. Totally delightful.
People often ask me, like, isn't it kind of depressing that you talk about death all day? And I'm like, absolutely not. My clients become my family. This planning is really something, it's a gift to the next generation in so many ways, that oftentimes my clients leave feeling lighter. Like, okay, I did something to get this figured out. I took a step that felt really overwhelming, and I feel really good about what we put in place. Even though the topic might be hard to talk about, the sense of accomplishment from getting something on paper and making sure you've thought through it so that your family doesn't have to, is like really freeing for a lot of people, actually.
Awesome. That's a gift. Thank you.
Yeah.
So Megan, part of your job, part of your role in the work that you do is in athletics. Tell me where that came from, and then let's talk NIL and most recent ruling on House versus NCAA.
Yeah, that's like a whole lot. We could do a separate. I speak on this a lot because, to your point, people are super interested in
So
how
fascinating
things are changing in college athletics. But
Yeah.
to your first question, how did it come about for me? I do high net worth estate planning and business succession planning and helping people set up companies and buy real estate. I do that for non-athletes all the time. And I've built a practice to help athletes and entertainers also do that. So from that perspective, what I'm doing for those clients is very similar to what I'm doing for my non-athlete clients. There's obviously some differences and nuances in doing it for a celebrity or somebody that people know. But it's not too different. And so that what I'm doing for them is very similar in a lot of ways for what I'm doing for my family business owners. And I got into it. I went to Marquette. I did the sports law program there. I worked at Nike during law school. And so really my first career was in marketing and advertising, and it just really kind of melded the two things together. And so I always knew I wanted to build a practice where I could serve people in that industry. And this felt like the most natural way to do it. And it's really allowed me to kind of blend both things. that I enjoy. And so I launched a sports law department at Von Briesen a couple of years ago, and it happened to be right when the rules on NIL were changing. And you obviously can't have a sports law department in this day and age and not be talking
Nope.
about NIL, because that's the most important shift.
Yep.
And what that is, really, to catch anybody up who doesn't know, is that there's been a shift in the regulations at the NCAA and in state law across the country that allows college athletes to now make money while they are playing in college by using their name, image, and likeness. So think endorsement contracts, licensing deals, they get paid for appearances, they can show up in commercials. None of that was allowed a few years ago under the NCAA rules.
Is that why I didn't get any contracts as a walk-on punter?
Yeah,
Back in the
that's
day?
it.
Was that
Had
probably
this rule been changed,
I
I
might
mean,
I
we
might
would be
be
talking about taxable estates all day, Josh. Those
a lot to
NIL,
absorb in my estate had I
yep, that's
timed that
right. These NIL deals would have been just off the charts. Yeah, and so it's always been the way of the world that college athletes were amateurs, and if you were an amateur, you can't make money in this way. The NCAA was trying to delineate between college athletics as amateur, professional athletics as professional.
Yep.
And through lots of time and evolution and money, that's totally changed. And now college athletes can make money while they are playing without losing their eligibility. And it's really fundamentally created a new area of commerce in this country.
No question.
There's new apps, there's new technology, these are the new brand ambassadors of America, right? College athletes of all different sports and all different walks of life are being used by companies as in ambassadors for their brands or their.
Well, and these and athletes move from being students and student athletes to student athletes and businessmen and women who are out there looking and seeking endorsement deals and building their own personal brand in a way that never happened 10, 15, 20 years ago.
Yeah. And there's
5, 10,
opportunities
15
on
years.
both sides, right? For the athletes, they are, and I speak on this a lot, so if you've heard me speak on this, you'll hear the same example over and over. They are now little entrepreneurs. They are startup companies, and they need everything a startup company needs. They need help with branding. They need accountants. They need lawyers. They need wealth advisors. They need people to help guide what they're doing. They need new companies set up. Like, this is a brand new world for them, and there's a lot of opportunity there. From a company perspective, there's also a lot of opportunity because these are local celebrities. These are people who carry a lot of connection and weight in their communities. And so from a company standpoint, I now get to both help a young person build their brand, but also have that young person communicate with their followers about my brand. And so from a company perspective, it's actually a huge opportunity for companies also.
So the settlement last Thursday, House versus NCAA, a significant $2.7 billion settlement, and the implications for what universities can, I think the threshold's $20 million they can pay their athletes on an annual basis. What happened with that? How did that come about? We only have a few minutes, but can you give us a quick snapshot?
Yeah, so there's been legislation over NIL for decades now. And the NCAA prohibitions on NIL payments were holding strong. Okay, they held strong for a really long time. And once those rules changed, then the NCAA was trying to figure out, okay, well, how is this new world going to work? And one of the main things in the new world was college athletes can make money on name, image, and likeness, but they cannot be paid directly from the universities and colleges. That all has to be private deals between companies, community organizations, donors, whoever wants this student athlete to come out and sign autographs or be at their holiday party, they pay.
Totally gray, by the way.
Yeah, they pay, right?
Very gray.
Very gray. Okay. And so what the significance of what happened on last week through this settlement is that in rough terms, the
Yeah.
NCAA and the Power Five conferences agreed to a settlement that would do two things. It would pay athletes from 2016, I think it is, until now, who opt into this class action lawsuit. It would pay them their NIL money because they were not able to do it while they were in school because the rules hadn't changed yet.
Yeah.
And what it also does is it sets up a system for universities and colleges to pay their athletes directly moving forward. That's the fundamental shift.
That's it.
And those are the two things that this settlement did. And we knew that something like this was coming. The NCAA took a major hit in a Supreme Court case a couple of years ago that shifted this first.
Yeah.
And so you knew the kind of dominoes were going to fall from there.
Yeah.
But this allows athletic department, universities and colleges to pay athletes direct. And I think they will be NIL payments. But it's basically, they're calling it revenue sharing because if the school makes a lot of money for TV rights or promotional rights or whatever to sell, the broadcasting of these games, then the kids who are showing up on the screen should be getting a cut of that. That's really kind of the loose theory of it. So yeah, it's fascinating. It's creating just something totally different in this country from a business perspective, a marketing perspective, a sports perspective. It's just fascinating.
And hotly debated in every household that watches sports, especially college sports, and whether or not it's a good or a bad thing.
Yeah, you can bring it up at your next holiday party and everybody can weigh in. It's safer than religion or politics, but it'll still get everybody jazzed about it.
It's so much easier to talk about than estate planning documents.
That's true, although that'll also get people really roused up. And in fact, it's a great
That's true.
picture if you want.
Yes. Yeah.
It's funny because the NIL stuff, like, it's talked about all the time. If I go to dinner, people are talking about it at the next table. I was at one of my kids' soccer games and the people next to me were talking about it, not talking to me, just talking amongst themselves.
Yeah.
It is a fascinating topic, something cool to watch. And it will, really change the way that we view sports. It'll create a professional or semi-professional model at the college and university level. Yeah.
Megan, thank you for joining us.
You're welcome.
You're
welcome. I hope people found it helpful, and
absolutely.
I'm here to answer any questions that people have too.
Good. For those who are watching, members on the platform, go to Megan's profile where you can download the 10 essential legal documents as well as other documents that Megan and the team post. Thank you for joining us here at Family.Inc. I would encourage you to check out the website, Family.Inc, for more interviews, resources focused on enterprising families. And then finally, after this discussion, you'll receive an email asking for feedback. We hope you'll participate. Thank you and have a great day.
Thank you.
Take care.